So we are going to resume the discussion and analyze the existing dispute resolution mechanisms that exist already in eSports. And we are going to have a very interesting discussion, I think, with Madalina Diaconu, Leonid Shmatenko, Julie Groffe-Charrier, and this panel is going to be moderated by Oscar Suárez. Oscar Suárez is legal officer in the business development and digital content dispute section of the WIPO. He has a deep knowledge of the legal and regulatory aspects of blockchain technology, crypto assets, NFTs, and alternative dispute resolution. Oscar Suárez is actively involved in implementing ADR solutions for digital content challenges and developing WIPO's ADR services. Given his expertise, I'm confident that he will bring valuable insights to the discussion. Oscar, thank you very much for agreeing to moderate this panel. The floor is yours.
Well, thank you so much. Merci beaucoup à tout le monde pour être là. Well, first of all, starting, thank you to Lextex, thank you Florence for the invitation, to Cletus with Federico, and of course, a pleasure to be here with Leonid, with Madalina, and Julie that is joining us online. So for starters, I'll give a brief introduction of our panelists today. I think they will have very interesting insights on what we're going to say the why of considering dispute resolution at this moment, and we can see this happening on the Bahrain files that were mentioned in this case, that competition trying to access the CAS, or we see also settlements like the Montum Games and Riot Games dispute on copyright and IP disputes that are actually settled. So this is the why that we're going to try to explore here. So I'll start first with Julie Groffe-Charrier. She's a senior lecturer, maître de conférence at HR in French, in private law at the Université Paris-Saclay, and a member of the CRD. She specializes in intellectual property law and digital law, and her research focuses primarily on video game law. Then we will have Leonid Shmatenko. Is part of Eversheds Sutherlands in the Data Protection and Technology Law team. He has a vast experience in regulatory and general issues in the areas of eSports and blockchain. He advises on eSports associations and clubs and all legal issues, also supports crypto startups in all matters, planning the preparation of ICOs. Furthermore, he has a vast experience in international arbitration, of course, alternative dispute resolution, which come to the SAC, to ICC, to DIS, UNCITRAL, EXIT, whatnot. And finally, Madalina is a Swiss qualified lawyer, having over 20 years experience in the legal practice. She specializes in sports and gambling law. Madalina is both a practicing lawyer and an academic. As a lawyer, she mainly represents clients in sports arbitration, notably at the CAS and also gambling-related proceedings. Before becoming an independent lawyer, she worked for the International Olympic Committee, the European Court of Justice, and the Swiss Lottery. Since 2020, she's a member of UEFA's Control, Ethics, and Disciplinary Body. And in parallel to her activity as a lawyer, Madalina teaches sports law and sports integrity of the University of Neuchâtel and is a scientific director of the FIFA Masters in Sports Management. And with this vast experience in this panel, I'll give the floor first to Julie. Julie, bienvenue, and thank you for being here with us today.
Thank you very much, Mr. Suárez. Dear Oscar, I would like to take a minute to thank Professor Florence Guillaume and the Lextech Institute for inviting me to this wonderful event. I'm really sorry I can't be with you today, but I'm delighted that the digital tools are enabling us to interact. I've been asked to talk about the different types of conflict and their resolution mechanism in eSports. It's a very important theme because it gives structure. A lot of fascinating things have already been said since the beginning of the afternoon, notably with Geoffrey and Patrick. I will not go into detail about the framework of eSports. A few words about the sector, however, simply to understand the diversity of the issues that arise from eSports in legal terms. eSport is a sector under construction. This need for a framework is reinforced by the fact that it's a really lucrative field. Today we are a long way from the gaming halls that a lot of us and the oldest among us knew in the end of the 1990s and the beginning of the 2000s. Video game is a cultural object today, and esports is now a colossal entertainment industry, and one that is only continuing to grow. There's a French report, a recent French report from the eSport Economic Observatory, and according to this report, the growth rate in turnover for companies in French esports sector over the period 2019-2022 is enough to make some other cultural industry pretty jealous. In fact, it rose. It rose from 27% between 2019 and 2020 to 54% between 2020 and 2021, and it reached 92% between 2021 and 2022, and the annual turnover is expected to reach 140 million in 2022. However, as in any new sector, in fact, disputes are gradually beginning to arise, and we can attempt to give an overview of the different types of difficulties that can appear in this area. There are several types of problems. I choose a few of them, but there are many more than that. Intellectual property, Geoffrey and Patrick talked about it earlier. Who is the owner of the game? Is he or she the owner of all the aspects of the game? There are questions in personal data also. Games now are very often played online, and how are the players' data collected? For what purposes? What about the professional players and their data? There are also questions, and we'll come back later to this, about contract law. The list goes on, in fact. However, in view of the time available to me, I would like to propose a slightly different approach. We need to consider the different types of disputes, but also, and perhaps above all in reality, the mechanisms for resolving them. The classic route remains recourse to the courts in the event of a dispute, but we can see another way that is gaining in importance, and that's what we call ADR, which are the alternative dispute resolutions. So firstly, the classic route and the recourse to the judge and to the courts. Naturally, when a dispute arises, the first reflex may be to turn to the courts. Even though esports is a recent phenomenon, there have already been a number of rulings that have made it possible to sketch out the initial contours of esport litigation. In France, for the past few months, the most interesting decisions are probably about employment law, and I chose two examples. The first one, and I try to make a schema about it. The first decision is handed down by the Rouen Court of Appeal on January 18, 2024, and it's about a fixed-term contract concluded between a company and an esport player. The facts are a little complicated, notably with the dates. I will try to sum it up. The player was 15 years old when he signed his contract in February 2020, and the contract was supposed to take effect on July 2020, the day he turned 16. But in August 2020, he received a message informing him that his relationship with the company was being terminated. So the player lodged claim for compensation, including back pay, for the period from February 13 to July 2020, because the player had worked during this period when he was not 16 yet, and the company had tried to hide behind the fact that it was only a promise to hire him for this period. And he also claimed damages for a breach of contract. The Court of Appeal dismissed this claim. The French Labor Code, le Code du Travail en français, states that except in exceptional cases that were not covered here, it is forbidden to employ minors under the age of 16. As the sole purpose of this provision is not the defense of a private interest, but the defense of a general interest, the contract should be declared null and void, an absolute nullity, which we call a nullité absolue in French. Consequently, if the employment control is void, it's not possible to claim payment of wages. Despite this, the player was awarded compensation of 15,000 euros for undeclared work for the period during which the contract was valid, which is in fact from the time the minor reached 16 on July 2020, on July 22, until August 2020 when the company terminated the contract. This first example really is interesting in that it serves as a reminder of the particularities linked to the age of players who are sometimes young in esports, and in this respect contractual arrangements can be paralyzed by the judge who applies the letter of the law, in fact, a fortiori when young players are involved. On the other hand, and this is the second case I wanted to talk about with you, a very recent decision 2 months ago dragged the attention of specialists. This was a decision handed down by the Paris Judicial Court on March 27, 2024. An eSport player on Counter-Strike had signed a services contract with an American club, but he obtained the reclassifying in employment contract. I will try to summarize the term of the disputes. It concerned a player who disputed that he had to pay the French URSSAF social security contributions specific to self-employed workers. And he argued that despite what the name of the contract chosen by the party suggested, it was in fact an employment contract. And in response, the judge looked at whether there was a relationship of subordination or not. If there was a contract of employment. If there was not, there was a services contract. And in that particular case, the judge considered that it was indeed a relationship of subordination by highlighting a series of indicators, the player's obligation, for example, to take part to competition, to wear the team uniform, to train 15 hours a week with the team, to stream for at least 20 hours a month, to take part in a reasonable number of marketing events, to promote the team and the company, all in return for a monthly payment. Here again, the judge demonstrates that while the contract is, of course, a precious tool in esports, it is not immune from scrutiny and, if necessary, requalification. This is an important decision for players in the sector, and clubs will need to be vigilant. In addition, what we call in French the CDD e-sportif, which was introduced by the law of October 2016. It's the law for a digital republic that Geoffrey talked about earlier. This law created CDD e-sportif, which is a short-term contract specifically for e-players. It was not well received at first by the professionals of the sectors, but when we see this type of decision, like the Paris Judicial Court that we just talked about, it could be finally a fairly convincing in-between in reality. And so there are plenty of scopes for legal disputes, particularly for these last months in the field of employment law. But if we are looking, for example, from abroad, from a French point of view, one case could make a lot of news in the coming months. Here again, Geoffrey talked about this case Earlier, it's a case from the United States, a professional team manager and a professional player have decided to sue Activision, which has closed all Call of Duty's competition except its own. This will undoubtedly be an exciting antitrust trial. The conditions set by Activision for allowing access to its competition are considered abusive by the plaintiff for a lot of reasons: the cost of entry fees, the participation imposed on sponsorship, profit, etc. The plaintiffs are seeking $680 million in a request for a jury trial that was filed on February 15, 2024. So we see that in the last months, in the last weeks, sometimes there are a lot of recourse to the courts in the field of eSports, but the judge is not the only one that can resolve a dispute, and the ADR, the Alternative Disputes Resolution, should not be overlooked, in fact. There is no shortage of adjectives to define esports. It's an economic sector, it's a sporting sector, but also, and perhaps above all, it's a cultural entertainment sector, and all of these terms suggest that esports is a sector in the spotlight. And precisely because it's a sector in the light, the parties will often prefer to resolve conflicts in the shadows to avoid the publicity of legal disputes. In this respect, mediation, arbitration are maybe less obvious at first glance, but are very well suited to this task. The solutions in French are diverse: conciliation, mediation, participatory procedures, settlements, arbitrations. And here again, many illustrations could be given. These ADR are implemented for doping issues, disciplinary bans, etc. We can focus on certain issues and mention the mechanisms that have been put in place by some actors in the sector through end-user license agreements, the EULA, but above all, the more esports competitions develop, the more alternative method of dispute resolutions become structured. A recent example, maybe, is the agreement reached between the WIPO, the World Intellectual Property Organization, and the eSport Integrity Commission, the ESIC. I admit that the choice of this example is not insignificant, as the panel is moderated by Mr. Oscar Suárez. This agreement seems to me unavoidable in the discussion. So there was a press release published on March the 5th, 2024, on the WIPO website that announced an historic and pioneering collaboration between the two bodies. The WIPO Arbitration and Mediation Center, renowned for its leadership in the resolution of intellectual property disputes, will work alongside ESIC, which is the standard bearer for integrity in esports, to improve and to implement state-of-the-art ADR mechanism to resolve IP disputes. This collaboration has for goal to focus on several key areas, including joint awareness-raising activities, the identification and training of neutral experts specializing in disputes resolution in the field of video games and esports, and much more. The two organizations will share their knowledge and expertise in their respective fields to support and guide collaboration with the aim of maximizing the efficiency and fair resolution of esport and video game related disputes. And we can quote Marco Allman, who heads WIPO Intellectual Property and Innovation Ecosystem Sector, who said, "At WIPO, we recognize the growing importance of ADR mechanism in emerging sectors such as video game and esports. Our collaboration with ESIC signifies a commitment to providing the necessary infrastructure for a fair and efficient resolution of disputes within the video games industry and esport community." So as a conclusion, I try to stay in the time that was available for me. Disputes in esports are becoming increasingly numerous in the years to come, and will become increasingly numerous for the years to come. But litigation will not be the only way to resolve these disputes, and on the contrary, it's clear that the alternative dispute resolution methods will play an increasingly important role in the sector. This is, I think, a further sign of the vitality of the sector, but also of its naturally international nature. And it's undoubtful that legal experts will continue to find new avenues to explore this area, and today's event, I think, demonstrates it very well. Thank you for your attention.
Thank you very much, Julie. And also, I think it's, well, thank you for the promotion there with the ESEC collaboration at WIPO. I have to say also that this is a collaboration that we signed very recently with the help of Leonid and Rodolphe, which have been like experts on the field. We've been working on this very closely, and it's a great segue we're going to discuss today, because I think you were exploring the labor side of the disputes and opening it to the IP context, which is always, as we will see when we talk about mediation arbitration, is the concept of the jurisdiction, also the possibility of using these mechanisms and if they're right or not. So now with this, I'll give the word to Leonid, because I think he's going to illustrate us with a bit of those examples. Thank you very much, Julie.
Thank you. Thank you, Florence, for inviting. Thank you, everyone. As an introductory note, I think when we all were students and independently researched, and you came on the same case law in the end, you knew you were with the prevailing opinion and you were following the right track. So at this point, we will see that everyone is citing the same cases here, the ones that are leading. And today I'm going to talk about the current dispute resolution mechanism in esports disputes, and whether we need an arbitration institution like the TASCAS in esports, with the initiative of WIPO and ESIC that is going to take place very soon, what we have now. And I think this goes hand in hand with what Julie has just explained, and what Madalina will explain after me. So what Julie already touched upon it, on the legal problems that we face in esports and that are subject to ordinary courts, and which can lead to disputes in ordinary courts, but also in alternative dispute resolution. This includes doping, cheating, match fixing, which is, I think, a big problem also in sports, in traditional sports, but especially in esports, in the lower leagues, where you have even a meme, which is called 322, where a Russian player lost on purpose for $322. So you will see if you Google that is an issue in esports. But you also have labor law disputes, you have questions relating to the law of foreigners, so immigration problems, and there you have administrative law questions facing that, and association law for non-profit status, which is, I think, immense more in the German realm, in the German jurisdiction, where esports teams and esports clubs are trying to get a non-profit status to be exempted from the taxes, like, for example, football clubs, volleyball clubs, and so on and so forth. So these are the fields which are covered by esports. It's an umbrella, and the problems are very much alike like in traditional sports, but with a twist to esports. So what we see here is a little bit of doping in esports, which is not a little bit, but there has been a bigger problem. And you see the headlines: e-doping needs e-laws to keep esports clean. Pro gamer admits to doping in esports. Doping in esports, an international solution to the problem that no one is talking about. Well, what do we have here? You think esports, why do you need doping? but you have seen in the presentation that you have 300 actions per minute when you have to highly concentrate, you have to micromanage your base in StarCraft 2, you have to be quick when you're aiming in Counter-Strike 2, you have to have a really, really high reaction. And what do people do? They take Ritalin, they take Adderall, they take Xanax to be less stressed, to be more concentrated, and to be concentrated on the game. What do we have? We do not have any testing there. It's trying to take place. ESIC is trying to integrate that. There is also WADA, who is trying to collaborate with the International Esports Federation, but there is no governance whatsoever, and it's the wild, wild west. Many of you maybe don't know what cheating in esports is or haven't seen. Here, for example, I have a video, and if it might be played, I think it should be possible. It's an integrated one. Here? Okay.
Guys, what's the command?
I love you, but I love you.
Yeah, why you say that then? Just CL physics.
So once you have seen it, I will.
And then highlight active 5.
So this is Counter-Strike 2.
Oh my god! They did not fix it. I have literally wall hacks. Chat. How did they not fix it? It came off yesterday. I'm turning it off. Oh my god, I feel like I'm getting banned. Why is it still on? Chat, what do I have to do? 1? 0? What the fuck? Restart game? Guys, I know that he's there. What do I do? Wait, never mind. Okay, dude. Guys, I have to restart game. Chat, all of our games will be like this today, no? Like playing against cheaters. No. Is it HVH right now in matchmaking? Tried an FPL. You're crazy.
So what you have seen here is a so-called wall hack. It's when people do insert cheats into the game so they can see through the walls. It gives you a major advantage about where the other player is, so you can calculate how to move. You can, if you're working through Discord or another service to communicate with your teammates, you can tell your teammates, look, there is one from the other party being behind the wall, so you can throw a grenade inside and you have a major advantage. So this has been also sanctioned sometimes because games do offer such wall hacks, for example, through some bugs or some cheat codes that people can inject into the game. So this is a dispute once, if somebody figures out that you have cheated during the game, which can lead to an ethical dispute, like doping, for example, or in the traditional sports matters. So, and as I mentioned, you have also match fixing in esports, which is a really big threat. It appears in lower leagues, but also in higher leagues, where there are whole networks of people. One can call the mafia, and the Russians are very active in that, which fix matches in Dota 2, in Counter-Strike, in the lower leagues, where there is no governance, where nobody is tracking, where there are betting platforms all around the world, where you can bet on even small teams in esports. And this is where we need governance. This is where esports is really grassroots movement. It's in its naissance. So this needs to be fixed, and this is where the WIPO and ESIC initiative is going to. ESIC is going to take the ethical part and try to provide for tournament organizers and for the publishers something that they can touch, that they can use in real life to fix such kind of disputes. Which brings me to ESIC. ESIC, I have met the CEO of ESIC during an esports conference in Taiwan in 2018. It was really, really recent that ESIC was founded. They had this idea of introducing something like the World Anti-Doping Association, into the esports business. So they took it from there, and they have created their organization, which has a code of ethics, code of conduct, an anti-corruption code, a doping code, a procedure code, and a prohibited substances code. And they're also enforcing it. If you go on the website of ESIC, you will see, which is esic.gg, good game. You will see that they have pronounced also lifetime bans to players. But then there we have another problem, and sorry from deviating a little bit here, but another problem is if you're banned in Counter-Strike 2, that doesn't mean that you're banned in Overwatch 2. So people can relocate from one game to another and be a pro gamer and continue doping and cheating there. So what we need here is also a centralized, probably, ADR tribunal, which will solve these questions and provide game-wide bans, not only bans to one specific game, but to the whole industry, like it is in traditional sports. So my topic is, what do we have today? What dispute resolution mechanisms are in? And there is a potpourri. We have everything, starting from the ICC over jams, the Swiss rules of arbitration at the Swiss Arbitration Center. And I just took a few examples from the most recent terms and conditions of the tournaments. So if we look at the StarCraft 2 World Championship Series, they have an arbitration clause for everything. And their arbitration refers to the jams. It's the rules of the American Arbitration Association. The American Arbitration Association, the AAA, they do administer many esports cases, but they do not have arbitrators who are specialized in esports. We have then the FIFA Interactive World Cup. It's a little bit earlier. I think it's a clause from 2019 or 2020, before EA Sports lost the license of FIFA and renamed the game EA FC 2024. So there we have, and it makes a little bit of sense for the FIFA, a clause which has the Swiss rules of international arbitration of the Swiss Chambers arbitration institutions, the SKY, before it was renamed to the Swiss Arbitration Center, with one arbitrator here. Then we have PUBG Mobile, which provides for the Hong Kong International Arbitration Center, which also might make sense because there is a huge community of PUBG players in Asia. So this is another one. Swift, we have mentioned it during the IOC, who have a knowledge that Swift might be an Olympic sport, an Olympic esport, or however you might call it, and they as well refer to the jams rules. But at the same time, Swift, as a first instance, has its own arbitration, alternative dispute resolution mechanism, which is administered by a law firm in Canada, and which is responsible for doping, hacking. There were cases where people were banned, and these people were not only banned for Swift tournaments, but also in cooperation with the UCI, the Union Cycliste Internationale. They were also banned for real tournaments because Swift is so realistic that real Tour de France participants are racing digitally against each other on the same route. So what happens there, maybe a little bit for background for you, is that the game or the simulator translates the track that you're racing into your cycle that you connect with the app. So this is why it might make sense. So then you have the Call of Duty League, which we have mentioned already and which I will mention a little bit later. They have the ICC, and the League of Legends, they have their own arbitration procedure, a whole dispute resolution clause on how to resolve their disputes. So as you see, it's a complete mess. You have 6 different games with 6 different arbitration clauses, and since arbitration is confidential, we do not know what the outcomes are, how it is solved, and how the problems are solved. So we do not have a body of case law, the body of case law that TASCAS has created in the last decades. And this is why, in my opinion, and I think in a lot of esports lawyers' opinions, a centralized or decentralized arbitration institution is necessary. And then we see, and this is what I mentioned in the beginning, the cases. It are the same cases. The Bahrain case that went to the TASCAS, and we have the arbitration in the Call of Duty monopoly dispute. There was an update. It used to be a litigation before the courts, but the parties, having read the dispute resolution clause, have both decided to go to arbitration. So this dispute is going to be resolved in arbitration as well. What do we have now in the esports realm for dispute resolution, which is supposedly to be specialized on esports disputes? And Madalina will touch base on the WISA arbitration court at a later moment. So we have this one. It's founded by the ESL and the teams which do participate in the ESL. I know from internal discussions with some of the council that there were 4 cases. This was in 2021. I haven't heard from them back. Neither did Madalina. But she will address it in more detail. We had the World Esports Consortium's KS, which is a world play of the Cour Arbitrage des Sports. It used to be there. I have checked the website a few times. It doesn't seem to exist. And when it existed, it did have only an arbitration clause which related to the members of the WESCO, which could only be organizations. So it was not related to, like, let's say, the pure esports disputes. And then we had MK Mediation, which was mediation proposal by a law firm, I think in the US. I don't remember it exactly, but this ceased to exist as well. The rules are not there. It just doesn't exist anymore. So what we have now is WESA, which we don't know how it functions, the potpourri of arbitration clauses in the rules, and the initiative of the WIPO together with ESIC. So we already mentioned it, and we hope that this will launch soon. So what are the pros of having a permanent esports arbitration court? So I already mentioned that it might lead to the avoidance of the fragmentation of law. So you have a body of case law where you can say, when there is a wall hack, then this would lead to such and such result. It can resolve all kinds of disputes if they're arbitrable. So ethical disputes, commercial disputes, whatever comes to your mind, except maybe if an issue is non-arbitrable, which is, for example, under German law, labor disputes. Labor disputes under German law cannot be arbitrated. So there might be a venue for mediation, because mediation might solve a lot of labor disputes due to misunderstandings between the employer and employee. And a centralized esports tribunal would also lead to the solving of the problem that I already mentioned, that you could ban for doping a player not only in Counter-Strike 2, like the ban pronounced by Valve, but also in every other game, because his violation does not refer to the game rules. It's a general ethical principle in esports that should not be violated. But a permanent esports arbitration court faces different challenges that are also peculiar to the esports business, because the publishers and the game developers own their IP. So to get this going, you do not only have to get on board the developers and the publishers, but also the tournament organizers, the players, and, for example, the streaming companies like Twitch or Kick and so on. So you must have everyone on board to have it done properly. All stakeholders must support that. And in esports, where tournaments are really, really following fast and the qualifications for the World Championships are now due, you have to have a platform which is not slow as arbitration can sometimes be in big disputes, but something that is quick, that delivers you a decision which is enforceable, and this is another pro of arbitration, which is enforceable in over 160 states worldwide due to the New York Convention. It has to be digital, because esports stakeholders, they are digital, and they have to have it quick at their hand, and they have to resolve it quickly. So you cannot wait months and months, because then it's going to be late. And this is what is missing. You have to have a list of arbitrators who understand what wall hacks are, what cheats are, how you can manipulate the hardware to inject code into the game. So this is another point that needs to be considered. And there might decentralized arbitral tribunals we do not know, we have not tested it, but they might be a solution, and this is open for discussion, where, for example, Claros, who's hosting this, or other, Aragon and Ure, the competitors, are offering something that might be a solution for such arbitrations. Why? Because you have in decentralized arbitral tribunals, you can not only arbitrate, let's say, smart contracts which are on blockchain, but you can integrate on the blockchain something that could also include awards which are there and which, except we get quantum computers in the next few years, will be proof that they're real. So you can always check on the blockchain when this award was entered. So what you would have is you source the cases into the platform. You have a pool of jurors which can be either appointed because they have registered themselves on the platform according to some qualifications. Say you are a lawyer from jurisdiction ABC, you have experience in esports disputes for X years, so you can be deciding this case. It becomes a little bit more like a jury in the common law sense. So this could be a solution to some disputes. So you get a better, cheaper maybe, and faster decisions. This could work. It has never been tested, but maybe it's time for a test run. And then we have mediation, as I said, for labor court disputes. And in Germany, this is something that could be an alternative. And I know for a fact, I have participated in some mediations, that in employment disputes, it's sometimes only a little thing that has upset the employee, that doesn't need to lead to a long ordinary court proceeding or to a long arbitration. It just can be a sorry that I didn't see your work, or thank you for the work in the last 3 nights that you have put into that, that could resolve the dispute. So this is why also mediation in esports, where you have a lot of minor players as well, could lead to solutions. And I think WIPO, with their mediation rules, which can be also tailored to esport disputes, offers a good alternative for that. So if you have questions, happy to answer them, or we can do it at the end of the panel. Yeah. So you will have the presentation for download, I guess, and there you can also read some additional articles on that topic. Thank you.
Thank you very much. Thank you very much, Leonid. I think that was very illustrative of the spectrum of ADR possibilities we have here, and the question of should we centralize all this somewhere. And of course, with this collaboration, we've been tailoring the ideas to find a stable institution that can kind of find the speciality of the arbitrators, the mediators, and also on the integrity side that ESIC brings in. And I think it's a very good question to see. Maybe we need a sort of cast task for this. I think the discussion will go on the other end now, Madalina. So please, the floor is yours. Thank you very much.
Thank you very much. Hello, everyone. I would first of all like to thank the organizers for this first conference on esports in our premises, which I think is extremely important and opens the doors for some very interesting discussions in the future. I'd also like to thank the previous panelists. I've learned many things from you, so thank you very much. And also my co-panelists today. I think we're going to have some good discussions. My focus, as you may know, is not esports. I'm not a specialist in esports, but I consider myself, let's say, mediumly knowledgeable in sports law and in sports in general. So my entire presentation here is biased because obviously it's from the standpoint of sports, traditional sports, and every time I have to address the issue of esports, I know I'm addressing it in a comparative manner, so there's no hiding about it. So let me deliver you my thoughts in this comparison, this broad comparison between sports and esports, especially from the legal and regulatory perspective, but with a focus obviously on dispute resolution. So let's go. If it's working, yeah, it's working. Yeah, I have to look, sorry. I'm confused with all the screens. I'm not an esports player. So okay, so this is the outline of my short presentation today. Because I'm closing this panel, I will also be wrapping up some of the very interesting things that have been said before me and also by the previous panel, but I will only insist on a couple of things which I'm going to go into details about, and those are already, you know, the CAS aspect and a presentation of the WESA's Court of Arbitration. So first of all, what are the lessons and the challenges that we've learned, or that I have learned so far? Very quickly, a wrap-up of the existing tribunals with maybe some new information about what was previously said. Is ad hoc a solution for esports disputes? And then we're going to focus, as I said, on two of the existing solutions, if we can call them solutions, let's say opportunities or possibilities. One is the CAS, and one is WESA's Arbitration Court. And then I'm going to try to draw some conclusions, but obviously I'm open to any suggestion on your part. So, lessons and challenges so far. As I said, it will be a very comparative presentation, comparative with sports. What I can say from looking from the outside into esports is that it really has the basis for the comparison with sports. So the challenges that you face and we face in esports are to some extent very comparable to the challenges and therefore the disputes that arise in traditional sports. I have only put here a few, but my distinguished colleagues have already talked about some of them, and Leonid was very specific about some of these challenges. So one of them, which for me would be the most interesting because that's my main focus in professional life, is match fixing. Match fixing occurs everywhere. Humans like to cheat. That's not news. So they also cheat in sports. They also cheat in esports. And one of the ways that they cheat is by fixing the matches, by throwing the matches, therefore arranging the result or part of the result or part of the course of a competition beforehand. And that obviously is something which is bad from not only from an ethical perspective, but from every perspective, because it takes away the main interest that people have in sports or esports, which is unpredictability. Whoever says competition says may the best man or woman win. Right? But if you take away that imprevisibility, that non-predictability, well, there's nothing left. There are a few, let's say, sports, if we can call them that way, like catch, which traditionally are fixed, and everybody know they are fixed, and it's the part of the game, and people still watch them. So, but those are more shows than competitions. So it doesn't go against the idea that match fixing is really a scourge, which is affecting both sports and esports, again, because people like to cheat. And I've only been through one, probably was the most important scandal of match fixing that I know of, but Leonid can correct me if I'm wrong. The one concerning StarCraft 2 in Korea in 2015, where it was more or less proven that a big part, if not the entire competition, had been rigged, had been arranged. So in this respect, we're in the same line, let's say, as traditional sports, and therefore, because we have the same challenge, we may infer that we may also have the same solution. We'll see. Another big challenge that I've seen very little information about, and maybe my colleagues can help out, is doping. Doping is a thing that actually happens, not only obviously in traditional sports, but also in esports. There have been a few discussions. Leonid has shown us some of the press articles, but there's nothing, in my mind, in my view as an external from this game. I don't think this discussion has been given its right place for the moment. You all know better than me, playing at a high level in esports, especially in some of the competitions which were shown, requires great skill, great coordination, eye-hand, but not only, great reactivity time, a lot of resistance, stress resistance, but also physical resistance. I have seen, for example, competitions whereby the base rule is that you're supposed to play for 18 hours a day without stopping, and then you sleep for 4 hours, and then you go back to 18 hours of playing, and then sleep for 4 hours. Well, obviously, whoever does that, I say chapeau, as we say in French, to you, because you must have an incredible life discipline to be able to resist to such tremendous pressure on your body and on your psyche. So obviously, what do people do when they have such immense strains that they put on their bodies? Well, some of them have recourse to doping. And the use of amphetamines seems to be quite well spread, unfortunately, among esport players, and other stimulants as well, but mainly amphetamines. And I don't think it's talked about enough in this industry. And as Leonid was saying, it's a bit the Wild Wild West. It's not something which is really regulated and not in a coordinated manner. Then there are all the contractual disputes, which Julie has talked about, and Leonid also has talked about previously, with most importantly IP rights, because this is the main chunk, let's say, of issues or problems which can arise in esports, but also unfair competition regulations, labor disputes, and Julie has presented some of them. So contractual disputes, that's, let's say, it's closer to home. For any lawyer, for anyone who is into litigation or arbitration, doesn't really matter, a contractual dispute is a contractual dispute. So there will be lots of similarities with the traditional approach to contractual disputes. And then there's the big issue, which is still an issue, and I've appreciated Patrick's presentation earlier, or are esports really sports, and are they recognized as such, and who should recognize them as such? What's the status of the recognition at national and international level? There's still a big question mark there, and I have also personally heard one time Thomas Bach, the current president of the IOC, saying that, well, he sees two big problems in recognition of esports as sports. One of them is the fact that there's very little physical involvement, let's say, little motricity which is involved, but that argument can be easily countered by saying, yes, but chess is the same, bridge is the same, they're mind games, and those mind games are still recognized and long recognized by the IOC as being sports. And then there's the second argument, which Thomas Bach had put forward, and many people put forward, especially when they're not from the esports realm, and that's a bit the elephant in the room, is violence. Direct physical violence, the objective of killing your opponent, which in many, or destroying their base and etc., which in many people's minds and in the ethical spirit of, let's say, more the European cultural, is something which is either unacceptable or difficult to accept. So these two things make the recognition of esports as sports quite difficult, but I'm not going to come back to what Patrick has said previously. It's just something to bear in mind when talking about potential disputes in esports. So very quickly, because this was already touched upon by my esteemed colleagues earlier, we have the disputes. What are the solutions that we have for the moment? Well, State courts, and Julie has presented some decisions by state courts, they seem like the natural recourse, right? We have a dispute, we go to the judge. I think everybody agrees here, and I'm not going to insist on this further, that state courts are really not the best alternative for esports. They were also considered not to be the best alternative for sports. But for esports, I think it's even more so, seeing the very technical aspects which are related to esports disputes. So we can actually say state courts should be out of the question, except obviously for domains or matters which are not arbitrable, where you cannot escape the natural judge. And Leonid has mentioned labor law as being one of the classical aspects, which in many countries, not just in Germany, but in many countries, ex-socialist countries, some Latin American countries, etc., labor law in most of its aspects escapes the realm of arbitration, because it has to be a judge to be able to, n'est-ce pas, confirm that the weaker party has not been grieved. Okay, so what do we have if not state courts? Well, basically, there have been voices, quite numerous voices, even lately, saying that the CAS, the Court of Arbitration for Sports in Lausanne, would be the natural replacement for state courts as it was for sports. And seeing all those similarities that I've just talked about between sports and esports, why don't we all just go joyfully to the CAS? That's one of the questions, and I will address that in just a second. The other approach, which was also taken, but it didn't really take off, at least for the moment, it's to have a specialized arbitration court for esports instead of going with everybody else in the bucket of sports. And that's the, ACES, there you go, ACES. Arbitration Court for Esports, which was created by WESA, and I'll talk about that also in a few moments. And then there's also the alternative, which is now being shaped with the help of my distinguished colleagues of this joint, let's say joint venture, if I may, between the ESIC, which deals, as you have seen previously, with mostly disciplinary matters, match fixing, fixing the games, illegal betting, doping, etc. I don't think they've ever had a doping case, if I'm not mistaken, but doping is among their, in their jurisdiction. Plus, the WIPO ADR would be taking over or could be available for contractual disputes. So this is a sort of a marriage made in heaven, whereby you have on one part you have disciplinary, and the other part you have contractual dispute being addressed at a high level of, with a high level of professionalism. So, because all of these has been already talked about by my previous colleagues, I will only focus on the CAS and the ACES in the next minutes. But before that, let's just answer the question, is ad hoc arbitration, or ad hoc arbitration a solution? Well, the answer might be yes, for obvious reasons. There are arbitration specialists in the room with us, so I'm not going to pretend that I'm lecturing you on that. I will just mention a few of the very classical and well-known advantages of ad hoc arbitration. Speed, which seems to be paramount not only in sports, but also or especially in esports. Specialization of arbitrators. The similitudes with traditional sports, which give us a pathway which has already been, let's say, cleared for decades now by the CAS and by other sports arbitration tribunals, so we can learn from them, and obviously confidentiality. And Captain Haddock would say also yes, I think, to the question. Okay, so to finish in, let's say, in beauty, what can we expect from the CAS as a potential solution for litigation, for dispute resolution, sorry, in esports, in international esports? Well, there are arguments for and arguments against, but let me focus on what I believe to be the main points here. First of all, the CAS, as everybody knows here, is a long-standing and experienced institution. It's almost 40 years old now, and it's been resolving disputes in sport for not only for a long time, but in a very consistent manner. The CAS has recently reached and exceeded its 10,000 cases threshold, so it's really a serious institution. If you look also at the quality of the people who form the CAS, not only the court office, but also the list of arbitrators, you can easily see that it's an institution which has made already has passed its test, let's say. And this institution has been proved already several times by the Swiss Federal Tribunal. It has also been proved partially, but with quite success by the European Court of Human Rights. So we know it's a good place to go of course, perfectible, but it's a good place to go for arbitration in sports in general. So thus, it would be a perfect, or it could prove to be a perfect environment also for esports. Some of the esports governing bodies right now have already chosen the CAS, and Leonid has showed us some of the arbitration clauses which point to the CAS. I only gave here one example, section B11 of the International Esports Federation statutes, which point to the CAS as the body to resolve disputes in esports. It has all the advantages of arbitration, but it also has some pitfalls, and to me, the most important one today is really the lack of specialized arbitrators. If you take the list of the CAS, the general list of arbitrators of the CAS, there are about 400 people there, even more. And I've amused myself into taking again the CVs of most of them and trying to see if I can find any connection with esports. I think I found 3. So very few people who are, or who say at least that they are familiar, if not specialized, with esports in the CAS's arbitrator list, and that's pretty normal, because if you take also the list of the same list of arbitrators and you look at the birth dates, well, I'm born in the 70s, but they were born way before me, so maybe esports is not really the thing that they would be more inclined to understand because simply of the age difference. So very few specialized arbitrators, and I believe that with all the good intentions in the world, if you don't have a good knowledge and maybe even a good experience of what you're going to arbitrate about, the arbitration process is not going to be very, very high quality, or you might actually miss things. And that's basically the main point that is being reproached, criticized towards judges, right? We always say, well, the general judge doesn't have an idea about sports, doesn't have any idea about esports, that's why we're not going to the judge. Well, the CAS right now is in the same situation. They don't have specialized arbitrators for esports. Another thing which for me is very important, because I've been practicing the CAS for a while now, comparatively high costs. All the practitioners in this room know that the CAS is expensive. It's quite expensive. To give you just a very broad perspective, and I welcome any other point of view from the audience, usually at the CAS, if you go for a sole arbitrator, they will ask you for a simple, let's say classical dispute, they will ask you around 15,000 francs as an advance of costs. And for 3 arbitrators, it will be more around 45, that's cheap, to 50 and plus 1,000 francs. The advance of costs. And again, this is for classical, simple disputes, not for disputes which we can see from the beginning might be very complex, and thus, of course, the taxes are going to be much higher. So if you look at those costs and then you look at the very, let's say, unharmonized level of winnings in esports, you can quite easily think that maybe it's too expensive for esports for the moment, or at least for the majority of, let's say, esports players or clubs for the moment. And there is no esports jurisprudence so far at the CAS, so we don't know exactly how they will position themselves. As several people today have said, there is this one appeal that was filed in autumn 2023 by the Bahrain Esports Federation, which is in relation with the Asian Games in 2023, and it was a dispute between a Bahrain player and a South Korean player, and if I remember reading some of the meta information about it, it was because there was a referee lacking in one of the games, thus the Bahrain team implied that their player hadn't had fair chances in the game. So, as far as we know, this case is pending in front of the CAS. I have contacted the CAS for more information, but I haven't received any answer for now, so I cannot guarantee the accuracy of the information, but apparently the case is pending. It has been reported by quite some serious media outlets, so And if the case is really pending as we think it is, it will pose one particular problem or one particular issue which maybe would give us more information in the future, and I think Patrick has touched upon this. It's how the panel, or the sole arbitrator in this case, will interpret Article R27 of the CAS Code, which says that the CAS deals with sports-related disputes. Is this going to be a sport-related dispute? Thus, will it be a de facto recognition by the CAS that esports are sports? We don't know, but it wouldn't be surprising, in my view, because simply if you look at the CAS's jurisprudence so far, the panels tend to be extremely wide and large and flexible when it concerns the interpretation of the notion sports-related. They have already adjudicated cases of mind games, of chess, etc., so why not esports? I don't think this would pose a problem. We don't know for the moment where this case is and if it's going to be going on the merits. We'll see. But if it does, it will be interesting to learn some lessons about the recognition, this de facto recognition of esports as sports by the CAS. And last but not least, a few words about the other institutional arbitration which was created specifically for esports by the WESA, the World Esports Association. Leonid has touched upon it also briefly. So I like how they called it ACES, the Arbitration Court for Esports. This court was created in 2016, and its headquarters are in Zurich. And it has published, and that's appreciable, it has published its arbitration rules in 2016. They're available on the website, including anti-doping rules and emergency arbitration rules. So when you look at the emergency arbitration rules, you think, okay, so they thought about speed. This is also something which could be very suitable for esports disputes because of the speed which is necessary, the celerity which is necessary to have in this kind of disputes. The problem is that, well, if you read the arbitration rules, in most points, I would say they are quite similar. The guidelines are quite similar to any traditional sports arbitration or even to any traditional arbitration process. So there are no big surprises there. However, still by reading the same rules, there are still some remaining questions which I have not found answers to. First of all and foremost, there is absolutely no information about how we can manage to prove that this court is independent from the WESA itself. And practitioners in this room may remember that this was one of the big problems of the CAS at the beginning when the CAS had been created by the IOC and was funded only by the IOC. The Federal Tribunal reminded us quite rightfully so that this is not an independent tribunal because it only depends of the IOC. And therefore the CAS had to be completely remodeled, and everybody who has studied sports law knows that. And so we are here now in the same stage of probably dependence of this court to WESA with this court. There's absolutely no information which was available. I've contacted also this court, I've contacted WESA to ask for case law, to ask for more information, and I haven't gotten any answer at all either. So transparency at its best. What we know from informal sources, which Leonid was kind enough to transmit, is that they have very few cases so far. So this court didn't really take off for reasons which may or may not be linked to legal and regulatory issues. So very few cases. They're not accessible anywhere. And the points which I have mentioned just by reading the arbitration rules, all of the set of rules are, well, first of all, independence, but then the list of arbitrators. They say, for example, in the emergency arbitration rules that they will publish on the WESA website the list of arbitrators and the list of emergency arbitrators. There's no such publication anywhere, and it is impossible from an outsider to know who are these people, who are the arbitrators, obviously to be able at least to name one. So maybe they will provide the list upon request. We don't know, but they haven't answered my request. So again, we don't know who the arbitrators are. There's an issue concerning confidentiality which differs from the CAS. You all know that the CAS cases which concern, for example, doping are not confidential by principle. Where here, by reading the WESA arbitration rules, everything is confidential for them. So including doping disputes would be confidential, which is kind of weird. Then adequacies of costs. If you look at their costs on the website or expected costs, they're still relatively high. They're smaller than the CAS, but they're relatively high for what could be asked from, let's say, the typical esports player. There's absolutely no provision whatsoever concerning legal aid. which is a bit funny also, a bit bizarre. And there's another point which is quite funny. Obviously, the arbitration rules in themselves don't have to necessarily provide for an appeal against the award, but the arbitration manual, which is, I suppose, a guideline attached to those rules, says that there is no appeal possible. So it's a one-shot arbitration, which can be actually quite problematic from many points of view. These are the points that I have identified as being quite problematic with this court, but again, we will probably not know if my points were right or wrong, because since this court doesn't have much jurisprudence, we'll see if it's going to actually even exist in the future. And these are my conclusions. Although we're all agreeing that eSports, and especially the eSports business, has had a meteoric rise recently in the last decades, especially in places like East Asia. The legal and regulatory landscape is still very incipient, and also the dispute resolution mechanisms are quite incipient. Some of them exist, some of them are in use, but as Leonid said, it's the wild, wild west. Both the CAS and the ACEs have their advantages and inconveniences. Well, more inconveniences for the WESA from my point of view. And the idea is that for the moment we're just imagining things, because all of these paths remain largely unexploited right now. In contrast with, for example, ESIC, whose case law is growing and is available on their website. So probably the main conclusion is maybe in 5 years from now, if we have another conference like this one, hopefully one of these courts or another kind of dispute resolution body will already have taken off and will already have some good jurisprudence to be able to show us. So this does it. Thank you for your attention.
Thank you very much, Madalina. I think it's very interesting, all that's been said. We've been talking about arbitration. I wanted to make a comment before. If somebody has a question, I would just want to mention something that is very evident when we're talking about this, but it's not mentioned very clearly, and is that international aspect of everything that we've been discussing. And I think that's where arbitration comes along. You were mentioning the New York Convention. Also, if we think about it, and I was just reading the list of jurisdictions that is not part of it, when we talk about mediation, we talk also about the Singapore Convention. And then when we talk about the Singapore Convention, for those who don't know, this convention is trying to emulate what the New York Convention is for arbitration, for settlement agreements that come out of it, mediation, at an international level. And then we have Saudi Arabia and Qatar that are not part of those. So we were talking about these big competitions coming in place. So we should think about arbitration as a tool that has been very efficient at the sports level. But when we're talking about adapting maybe mechanisms to the realities of esports, which are parties that may not have the resources to engage into a big arbitration at the beginning, mediation can be something. And we know we're going to mention this later in the formal presentation, but I think it's a very interesting tool to consider in this international dispute that will facilitate and will kind of answer all these questions of speediness, cost reduction, and like trying to solve also, which is something very important that we see at least in the IP level, and is the cooperative environment that should all the system be in place in order to work in the end. So that's my only comment. I want to like kind of to wrap it up and say like, let's angle it this way too. I don't know if anybody has a question. Maybe we have time for a couple of questions. Florence, if you agree? Perfect. Anybody that would like to, or then if you have any comments about what you think about maybe considering something different, you have my, yes, please.
So maybe a comment on your comment. I think that mediation could be a great tool to put in place because of the specificities of eSports, and that would be one of the main differences with sports. Because right now, mediation also exists in sports. The CAS offers a mediation service. Actually, when you file a case, the very letter by which they acknowledge the case, they put a paragraph by saying, remember, we have a mediation procedure. Would you like to go to mediation? In my experience, and it's been years, I've never seen a mediation procedure that actually worked in sports. So maybe it will work for esports, and that will be a good difference with traditional sports.
Please, Leonid, if you...
I think what we all also forgot to mention is that a huge bunch of esports athletes are minors. So we will be facing another, in the labor disputes, yes. So we will face an issue also in the arbitrations of representation. So they will have to be first represented by their parents, and those have to eventually hire counsel. And the strategy is going to be evaluated all together. So I think this is a rather bigger challenge than in traditional sports, where you also have minors, but not on the professional level yet.
I think we have one question online first.
Yes, please.
Okay, so maybe I'm going to read it to help you. So
Should we
first
go with
one,
the first one?
yeah, it's okay
you can
for
all
you?
read it, so I may
You want to
read it out loud.
You want me to read it, or it's okay?
It's easier than doing like this, so yes.
You want me to read? Yeah.
Yes,
Yes.
please.
Okay, so the first one is, what are the most common types of esports disputes you come across in your practice, and what is the most preferred way of settling them? Good question.
I had just a few, not even a handful, but it were it were prize monies and bonuses that were not paid to the players, and two, more on the commercial side, sponsorship agreements with teams. So there are certain rules as to sponsorships. For example, if you have a Dota 2 or Counter-Strike team, the rules do allow betting companies to sponsor your team. But games like League of Legends, etc., or that are published by Riot Games, they do not have that option. So usually, and this is quite funny, also maybe from an international tax law perspective, that the sponsorship agreements foresee payments in cryptocurrency. So you would maybe, for that kind of dispute, certainly have smart contracts that could be incorporated, that could be solved in a decentralized court like Claros. These are the disputes that I saw, and mediations in the labor law realm, because I'm more from the German-speaking part. But yes, that's what you also see in the case law that is emerging in France, especially, but also in Germany, that the qualification between an esports athlete, whether he's an employee or whether he's self-employed, becomes really relevant. And this is also relevant not only from the labor law perspective, but also from the tax perspective and from the health insurance perspective. Because these e-athletes with actions per minute reaching 300, 400 per minute, they also suffer a lot of injuries, especially in their hand. And those can be really costly when they're being treated, and whether you're injured or not becomes a really crucial question.
Maybe I can add something. I haven't had esports cases, but I've been thoroughly looking on the jurisprudence of the ESIC lately. So for disciplinary matters, what seems to be the two types of litigations, disputes which seem to be the most frequent, are match fixing and cheating in the form of placing bugs. So those two things seem to be the most frequent types of disputes in front of the ESIC.
If I may add there is recent jurisprudence from the US, I think it's 2 or 3 days old, where Bungie, the developer of Destiny 2, sued Romanian cheat developers and actually won the case. And Bungie is doing it a lot. Bungie has a case law of suing cheat developers because Destiny 2 seems to be a honeypot for cheats or bots. So, and the damages that they get are quite high. In one of the arbitrations, Bungie received damages amounting to $16 million.
Okay, maybe we try the second question. Well, okay, be careful because it's not easy. In your opinion, could EU competition law restrict the monopoly granted to publishers by their IP when it comes to organizing competitions?
Well, it's not
Go
only the publishers who are organizing the competitions. There are different layers. There are the community tournaments, which follow certain rules that are set by the publishers on how to use IP and how the prize money can be. Every single game, I think there are 52 esports titles that I have counted lately, has rules that do allow or do not allow something. There was recently an outcry for Nintendo's rules on Super Smash Bros., what community tournaments may or may not do. There was an outcry about the Street Fighter tournament. This was amended by Capcom just like after the community cried out. There has been the Call of Duty League antitrust arbitration that is going on in the US. We had recently the ECJ ruling on TASCAS and the monopoly of the TASCAS regarding sports jurisdiction. So if the DG Comp of the EU thinks, and they might, also with the new Digital Services Act, they might get in and they might try to, well, decouple the esports tournaments from their publishers, like they did it in the gas sector, where they decoupled the transmission network from the gas suppliers.
From a purely technical point of view, it could be a perfect case from the perspective of European law of application of abuse of dominant position to this kind of situations. And since it is clearly an economic activity, I think that if a case was presented, either the Commission or the court would thrive on such a case from the competition law perspective.
Yeah, and by analogy, there has already been a decision from the European Tribunal, the first European Court on September 2023 about Valve and 5, I think, publishers of video games, and the European judge decided that, you know, it was about activation keys that were blocked on some European territories, and the European judge said that it was an abuse of position.
Well, on that note, and in order to respect the time for the next panel,
Well, I
think we could...
Yes, we can have one more question.
Okay.
If you are okay.
For sure.
So, Patrick
Thanks,
Piton.
of course.
Yeah.
It's not exactly a question, it was just to follow up on some of your comments. The first one is mediation is definitely something important, and even within the Swiss eSports Federation, we at some point ask ourselves if we have to set up something. In the end, we didn't go for arbitration because it was too complicated and too expensive. Leonid, I think you remember, we talked a lot at that point.
Yes.
And then they ended up with a sort of a mediation thing and I think since then it's going well, and they, for now, settled their dispute like that. And regarding the cases, a lot of cases or concerns for Swiss teams are related to employment or services agreement, depending on how they call them, because some big companies are coming now in Switzerland and creating some teams. They have much more money than other teams, and they are stealing the best or the best players who are then breaching their agreement, whether they are services agreement or employment agreement. So the concerns of small teams first were, is this an employment agreement? Can I sue my former athletes? What do I do? Is it a services agreement? So can you just like go whenever you want? So that's one of the typical disputes we have in Switzerland, if you can say.
And if I may add some anecdotal story also that I know from the German Esports Federation from within, they do have an arbitral procedure. There were 3 or 2 cases, I'm not sure. I have spoken to someone who's also involved. And the experience that the participants had were that they said, I do not want to do arbitration after that anymore. It's horrendous. So that brings me back to my presentation, that if you want to offer such services, they have to be tailored to the esports realm, to the esports bubble. Let me put it like that. So you have it very quick, very good, and very understandable for the layman.
And I think that's the spirit of what we've been working with ESIC, with you. The discussion about how we can make it, what Rico and Claire is like, how we can make something that will be not only in theory very nice, as we've been seeing all these institutions opening rules that in the end maybe they're not effective because they're not reading into the needs of the parties and not just pretending that it's a one-size-fits-all kind of approach. So I think that's the main message of what we've been discussing here today. And on that note, I think we can
I think you
proceed,
can
or
also
wanna-
then
sorry.
answer the last question that I saw, that whether
Yes.
the WIPO
sorry,
tribunal
I
would
didn't
be
see.
also covering
Would you, would
disputes
you like to
outside
say
of the IP realm.
Sorry.
Yes, because I think
Is
that
that I can
Leandro, maybe Leandro is going to speak about it, but if you want to say something, can we have
give
the
an
question one more
introduction
time?
then. Of course,
on the
could you
screen?
just show me sorry, I didn't see the question.
Yes, thank you. It was, will the WIPO ESIC body be competent for disputes outside the scope of IP-related disputes? So
Yes.
I don't know if Leandro is going to talk about it.
I'll give a
bit,
little
we
taster
are
of
pleased
what we're going
to-
to discuss on that with
to
Leandro's
Hear your
venue.
answer.
So the idea is to create a one-stop shop where we could say, okay, we're going to be here deciding disputes that are of 2 natures. And we were talking very clearly at the beginning that in the realm of the esports, the publishers are king or queen, meaning they're the ones that are going to allow you to use the system in the end and compete and whatnot. So there's a big, huge IP aspect of it, which is very natural to WIPO as an institution helping the IP environment. So we are very knowledgeable in fixing and helping fix those disputes that are quite related to IP. And I can tell you one very easy example. Broadcasting rights of esports competition online. We've seen those cases already. So those are very IP strong, IP intense cases. But at the same time, we acknowledge, as we were saying, that esports also has this big part of integrity. And those are like the 2 big issues. So the idea of this venture of working with ESIC, working with WIPO, would be to provide all the knowledge on dispute resolution that we have, being existent since the 90s till now, with all the caseloads that we've seen in very different domains. With that expertise, bringing the IP side, and at the same time, helping ESIC in solving all those disputes that relate to the integrity, and hopefully being able to kind of have a specialized esports center to solve these disputes. That's more or less the intention, and that's why it's taken a bit of time to finish the tailoring of it.
Okay, so thank you very much. Thank you very much for this very interesting presentation and discussion about the existing dispute resolution mechanisms in eSport. Thank you, Julie, for coming and joining us online. Thank you very much. I know that it's not a very easy exercise, so thanks very much. Thank you, Leonid, Madalina, and Oscar for your insights. And,